Have you received a letter from your ex's lawyer and you're not sure what to do? Or are you wondering whether you're allowed to reply to your ex's lawyer in emails and letters? Well, today's episode is for you because today we're going to be covering that question that we get asked a lot about, can I respond to my ex's lawyer? And we're going to be touching on any rules or boundaries that may apply when writing to your lawyer, how to stay calm and empowered when dealing with intimidating communication, and also learning how to stay respectful, clear, and proactive in your letter writing. Welcome, Mum.
Hello, Laura. Hello, everyone.
So you just read a stat out to me just really quickly. You said it was how many % self-represented in the court?
I think it was 1 in 4 or 1 in 5 cases have someone unrepresented. And that's for the trial. So the number's around like 39%.
Yeah. And so, but lots of people don't go to trial, but they may just turn up one day, a letter will turn up from their ex's lawyer saying, I act for someone. So today we're just going to go into what are you allowed to do? What are you not allowed to do? Because I was surprised some people didn't know about some of these things. We're going to touch on them today, hopefully provide you some support. Let's get to the jingle and then let's get started.
Hello, I'm Laura Furiosi, divorced mother of 3, and I'm here with my mother, Lynette Galvin, with 35 years' experience in family law. You're listening to the Divorce Course podcast. Through our candid discussions, we hope to help you through your divorce or de facto separation. We will be answering the most commonly asked questions and covering the stages and steps that you will face on your way to freedom.
Firstly, Mum, before we answer the question, why is receiving a letter from your ex-lawyer so stressful?
It is, isn't it? But, well, think about it. If you've even got a lawyer, even getting your own lawyer's letter can be quite stressful, right? And so I think it's the letterhead, the stern sort of way that they talk and they use your surname, that kind of thing. And they talk about, in the letter to you about your ex-husband or wife, they refer to them as our client. And it feels like that's 2 against 1 for a start. That's how I think it does.
Well, for me, I felt like I was in trouble, even though it might have just been an introduction letter or a this is what's happening letter or an invitation to mediation. It just immediately makes you feel like you're in trouble because let's face it, you don't really get letters like that.
From solicitors.
From other people or other things. So it is and I know I've talked about my avoidance, head in the sand moments that I've had through my own personal divorce. And opening an email or opening a letter was hard. Like just opening it was hard. So I understand if you're listening today and you feel that way. But there's also the additional emotional challenges of once you've read it, or are you freaking out? Are you crying? Are you upset? Like there's all these emotions that come just from opening a letter.
And that can happen even if the letter's from your own lawyer.
Yes.
I mean, I've always said that I could put a nursery rhyme in a letter to someone and they will freak out because of the letterhead, because of how formal it looks. And that's back from the days where we used to actually send a lot of paper letters. So I understand it.
Emotionally, if anyone is listening today and they have freakouts when they're reading these letters, just remind yourself it is just words dressed up in a lawyery way. And you can take some of the impact away if you just focus on the words and maybe put it into plain speak. But we're not talking about reading the lawyer letters today. We've got a great episode on that that you can listen to. It's called Read a Letter Like a Lawyer, where we take you through 7 steps. But what we're going to be talking to you about today is writing to their lawyer. So the question we get asked, Mum, the big question we get asked is, are you allowed to write to your ex's lawyer if you're self-repped and you don't have a lawyer yourself?
Yes. Otherwise, how could any discussion happen? You know.
So we have people asking the question, I haven't been able to answer because I haven't got a lawyer yet. So you're saying you don't have to have a lawyer to respond to a legal letter.
Because the letter is sent to you, right? And if you don't have a representative, then you are the person who responds.
Can you write directly to their lawyer? If you do have a lawyer and you're like, I just want to cut through the crap and get into the nitty-gritty of this and respond myself, can you do that?
Well, you can, but you shouldn't, because it will bring down a hail of trouble from the other side. If you're represented, your representative has to write the letters. If you want to do that part of the work yourself, you either keep your lawyer as guidance, but don't have them put their hand up and say they act for you and you do all your letters. Or you have to say to your lawyer, I want to do this bit myself. You're sacked, I'll represent myself. And your lawyer has to let the other lawyer know it's okay to communicate with you, because there is this protocol, it's a procedure that if you're a lawyer, the husband's lawyer or your wife's lawyer can't speak to you if you've got a representative. And a way to look at it is this: you wouldn't want the other lawyer contacting you directly, even though you've got a lawyer, would you? And so they as lawyers are forbidden to contact you if you've got a lawyer.
And so Mum's saying, if you've got a lawyer, your lawyers need to talk to each other. The lawyers talk to each other and you stay out of it. If you don't have a lawyer, you can talk to their lawyer because you're self-representing, so you're the representative. What about if neither of you have a lawyer? To write letters to each other?
Well, yes, but be careful not to overdo it and find yourself like being accused of being perhaps abusive or, family violence or bombarding.
Okay.
So the same principles apply, and that has to be respectful.
Okay. Now, from a personal point of view, and I know there will be some people thinking this, okay, they've got over the hurdle of, yes, I can write to their lawyer. The next hurdle is, oh my goodness, how am I going to not look like an idiot writing to the lawyer? So before you answer that question, Mum, how many self-repped people wrote to you in your practice? Were you used to it, or was it a rare thing?
Yeah, I was pretty used to it. It wasn't, I don't think it was as much as it is now. Technically, if you are representing yourself, you can phone the other person's lawyer if you want. But I personally, as a lawyer, required everything to be in writing, just so I didn't get accused of verbally. And you may find that your ex's lawyer wants only to communicate you by email. And frankly, it's probably a more efficient way of doing it. But yeah, we had enough of them. And it's important to be respectful for both parties.
Okay. So just touching on that, where you said it's better to do writing than phone. So there's email, there's snail mail, that's the posting stamp, and then there's phone calls and face-to-face. So what's the best way to communicate? What's the best way for a self-rep person to communicate? And are there any legal risks with either of those options?
I really think email is the best way. I think that you need to make sure, risks-wise, that you've sent it to the right place, that if you haven't put like the receptionist's name or whoever your letter that you received says you've got a right to, use that email address. So that's a trick. And if you're the first one to write, phone their office and ask the receptionist for the proper email address so you get it to the right one. So that's one little trick. The other one is that if you just send it in an email, there is always a risk that it could be tainted somewhere along the way, that people can get into it and redo it. So it is preferable, if you know how to, and probably everyone does, send it as a PDF. And then you've got it, lock solid.
So you write your letter like in a Word document, convert it to a PDF.
Yep.
Make sure it's signed and all of that. You can do that electronically or you can scan it if you want to sign it by hand. And then you upload it as an attachment to your email. And what do people usually write?
They please see attached correspondence. Okay. And they might put a date. Okay. And there's usually nothing of substance in the email itself. It's the PDF that has everything. It's safe. It's protected. Sometimes you can have a setting on a Word document that whenever someone prints out that document, it updates the date and things like that. And I've seen a lot of confusion with that. So it's better to do the PDF. And the court actually says you can use those apps on your phone to take a photo and upload those. They seem to be happy enough with that.
Okay.
So, yeah.
And phone calls probably not a great idea because it's a he said, she said situation and you can't record it.
Well, I'm afraid you'll be outgunned. We're teaching as much as we can through the course and through these podcasts, but I remember the day, little war story here, years ago when I was working out what sort of law I was going to do. And I had a personal injuries case. I had lots of other cases. I rang up the lawyer on the other side and they absolutely ate me up and spat me out, most politely. But I hung up and I thought, oh, how can I compete with someone who does nothing but that sort of law? So I got rid of all those files after that. And I feel that if your ex has got a lawyer who is a family lawyer, for instance, you don't have a chance in a verbal conversation with them, okay? And you don't get a chance to take words back or hold them to account if they say something.
Or think about the answer for more than a millisecond.
Yeah. And that brings me to the other one, Laura, is don't write in anger. Don't.
Well, let's get into that.
Yeah.
So what tone and structure and language is best to use when writing to lawyers? So, what's best to be put forward so that people don't make a bit of a dope of themselves, I guess.
I think that don't try and use too many fancy words. Just be plain and firm, but fair, okay? And clarity, I think you said, Laura, before. That's perfect. You can use our compass for this, that it's that it's got to be nice, it's got to be precise or exact, and it's got to be not too long, and it has to be in
friendly
manner. Yeah. So I would suggest you do that. I would stick to calling the lawyer on the other side by their Mr. or Mrs. or whatever. Keep it formal. And when you sign off, use your first name and your last name. Don't say you're Mrs. such and such or Ms. such and such, because the file there might be several Smiths or whatever.
Okay. So in structure of a letter, is it usually the address, the date, the RE? So the RE is what? Regarding?
Is regarding, yep. So you'll use whatever, if you're answering a letter, you'll use the same things they write. But if they say our client Malcolm Smith or something, you might say your client Malcolm Smith,
And that's usually in bold and underlined.
Yep.
And then you write the letter underneath.
That's right. And it's just, the re is just so they know where to put it. Sometimes you'll get a reference to, which will usually be 2 or 3 letters, a colon and then a number, which is the file number. In a very big firm, that's very important to put that there so the receptionist knows where to direct it.
Okay. And that's if it's snail mail, but you still do it in the
email.
PDF, in the email.
Even in email. And even and make sure in an email the subject matter is important, but don't put anything of substance there. Just put and put your client such and such.
Okay. What should you absolutely avoid saying in a legal email or letter?
Being angry. Don't be smart. Don't be angry. If you're making allegations, try and take the emotion out of that language. But really being angry, or I think smart, Alex. I think, honestly, most people are very nervous. Our listeners will be nervous and wouldn't dream of saying any sort of, cheeky thing. Snarky thing. But the people who don't accept that the solicitor is any better than them, if you know what I mean, or more educated than them, you'll often find them doing some smart aleck response, as you have heard before.
Why avoid that? What trouble does that cause?
First of all, there's 3 things. 1, it makes the lawyer a bit cranky at you, right? 2, it'll make your ex cranky at you. And 3, if it finds its way into a court document attached in your response, the judge may well form a view about you that you don't want the judge to form. You want the judge to see you as reasonable, focused, and responsive, and aiming at settling the case. So if you say anything nasty or snarky in a letter, then you won't be able to negotiate it as well with the ex. It doesn't mean you can't tell your truth, right? But don't be snippy or smart alecky about it. That's why I think if you can, you leave it for 24 hours and have another look at it.
So are there any phrases that you've used in the past in letters to kind of, help or protect you when writing back to a lawyer who's very aggressive or very full on or just out of control of it? Are there any common phrases that the people listening today could just kind of hang their hat on if they're desperate?
My favourite, and as grumpy as I would ever get in a letter, would be, I am indeed surprised that you would say this, or at the tone of your letter, or with the greatest of respect means the absolute opposite. For listeners, I think you can say those things. You might refer the lawyer to the central practice direction and the way that people are required to communicate with each other. You know, if you feel their letter is a bit snippy, you might bring them back down.
So we might put that in the show notes so you guys can have a look at the central practice directions. It's got rules on how lawyers should engage and communicate. So you can remind them of that if they're big poo-poo bums.
Yes.
Mum, what are some really common tactics that lawyers use that you've seen where they're trying to pressure or confuse you? What can people look out for when, and I guess even if your ex is writing to you, where you get this letter and your immediate response is to react in a way? Do lawyers ever write letters to kind of get that reaction from self-repped people?
As an honourable representative of my profession, I would say no. I don't see that there's any benefit to the lawyer. However, lawyers act on the lawyers act on their clients' instructions, right? And so there may be a letter because the lawyer's been given bad information. I understand, Laura, there are some lawyers who really shouldn't be practicing. They just cause so much harm. But yes.
But do lawyers write letters to trick people or to catch them in a lie? Or is there anything that you've seen where they make people be manipulated or controlled or scared or intimidated? You must answer by 5 p.m. today, that kind of stuff.
That sort of stuff. Yes, I think all of the ways that I've used with correspondence is all focused on getting things to the end and getting it resolved. But I hear you in those sort of complex ones. Sometimes their emergency date, their deadline is not realistic, and you can just write back and say, that's not realistic, I need more time. And remember our triple F ones, our 5 to 5 on Friday afternoon. You get those letters through, and that sometimes I think is a stalling tactic or a nasty tactic, or it might be that the lawyer's just so busy.
So when Mum's talking about the 5 to 5 letter on Friday, it means that the lawyers have written to you 5 minutes before 5 p.m. on Friday, saying some huge bombshell and leaving you on the weekend to freak out about it. That plus really short deadlines, they are some real intimidation kind of tactics that can be caused. So you've got to really, like Mum said, those timelines are a guide and you can ask for more time if that's reasonable.
If it's reasonable, yes.
And say, I haven't got time to respond to this in the next 5 minutes or I don't have time to get that answer to you in the next day. Can you please give me a week? Or, so you can negotiate the times. Is that right?
Yes, that's exactly right. You're entitled to take some time to respond. And if they send a 5 to 5 on Friday, if my clients, I would not have passed it on to my clients unless it was something particularly urgent, and we'll talk about it on Monday. So sometimes I think lawyers are just busy and they say, I must get this done this week. And then everything gets sent at 4:30. The staff is sending them up. But I may be Pollyanna, Rose.
I know you keep saying Pollyanna, but you're just very optimistic about your profession, Mother.
Right. But there is one other aspect, and that is it's quite a serious aspect. If a letter is written to you and it makes certain allegations about you that you deny, they're not true, they're absolute rubbish, to not answer at all is to admit that they are true. And so you need to read every word, every sentence, and if there are allegations in there or wrong things, you need to set the record straight when you write back to the other side. Otherwise, they'll end up putting a string of correspondence with the wrong story to it. And the fact that you didn't respond can be taken as that you agree with it. So you've got to be careful just ignoring correspondence.
That's important. And if you haven't got our 7 steps to reading a legal letter, we take you through, and that's one of the things we do, underline the accusations and the things you need to respond to. So we'll take you through those 7 steps. So go listen to that episode. In the show notes, you can download the free checklist. I should probably put it in the free resources as well. But reading a letter like a lawyer is a great one. Mum.
Yes.
The people listening today are most likely self-repped.
Yes.
Right? Whether they just haven't got a lawyer yet, or whether they had a lawyer but now they're tapped out, or maybe their lawyer was painful, or they're doing step in, step out. So what does the family law courts of Australia say about unrepresented people? Are there any rules, are there any guidelines for them?
Yes, they set those rules out fairly early on in the litigation, in the history actually of the Family Law Act. And one of the cases is Re F, and the other one is Johnson & Johnson, and we'll put them in the show notes, where the court explores exactly how a judge should work with a person in the court who's self-represented. And it's a very fine line for the court, particularly if your ex turns up with a solicitor and a barrister and you're there trembling and having to speak for yourself. So there are a number of things the judges can do and should do to help you understand things, but they aren't there to make your case for you. So they've got a very fine row to hoe. If they start helping you too much, the other side will go, oh, you're biased, right? And so there are these guidelines they've got to follow. But in the end, you're really on your own in court, acting for yourself.
Okay, so what is it? What is the written guidelines? What is that again?
It's Re F. F for Freddie. It was when we were using initials for the court cases, but no one can remember them. And so they've gone, and Johnson & Johnson isn't their real name either. But those two cases will tell you what a judge can do. As for what lawyers can do with self-representatives, they also have to conduct themselves with a certain degree of restraint. And I've seen criminal cases where a lawyer implied to a person who didn't have a lawyer that they would be charged $165,000 in costs if they didn't send $10,000 over straight away. And that's a criminal offence. It's a well-known case. It involved a politician. But so the lawyers had to walk the line as well. And law societies give us some guidelines, and the court gives us guidelines how to treat a self-rep.
So we'll put those and the cases in our show notes for this episode. So if you are interested in reading what the judges need to be doing, go and have a read of that. What if, and I have heard of this, Mum, which is weird, where the lawyer refuses to deal with you, or I've also heard of their ex refusing to deal with their ex unless they get a lawyer.
The ex can refuse to deal with you. That's their prerogative. And you don't have to get a lawyer. There's no rule that says you have to have a lawyer in these early stages.
Well, in any stage, there's no rule you have to have a lawyer at all.
Well, there is. If you get to final trial and there's an allegation of family violence, there is an absolute prohibition on a victim or an accused person cross-examining the other person in person because of the family violence dynamics. And so the federal government's made money available so that those people under Section 102, N for Nelly, A for Alpha, can get themselves a lawyer. But every other stage...
But everything else, writing letters, all the way up until final trial, you don't have to have a lawyer.
No, and many people, I mean, it's amazing.
Need to start doing your disclosure but have no idea where to start? Feeling overwhelmed about mediation coming up? Or just trying to deal with negotiating with a manipulative ex? Then you need to go to thedivorcecourse.com.au to go to the free resources section where you can get a mediation checklist, a disclosure checklist, a word salad, read a letter like a pro checklist, and also a before you go checklist. Get ahead of the game and be organised and ready, as this handy checklist, along with the accompanying episodes of the podcast, will be perfect for you. All you need to do is go to thedivorcecourse.com.au and go to the free resource section and download the free checklists today.
I'm impressed with people who can get all the way through. And you don't know what you don't know. That's the trouble in a trial.
That's right. But what do you do? So say they're not at trial, they're just writing letters to each other or going to meet up. So what are they supposed to do if their ex's lawyer says that they're not going to communicate with them?
I think you need to threaten them with the Law Society, complaint to the Law Society, because you must be afforded an opportunity to deal with your matter. If they tell you why, like if they say we're not going to talk to you because you've got a lawyer, then you can you deal with your lawyer to notify them that they're no longer acting, and then you should be able to open those communications. I think some people are just ill-informed. Some lawyers just think, oh, self-rep. But I did not take phone calls from a self-represented person just for my own protection as a lawyer.
Can you be forced to get a lawyer?
No, except in that one circumstance that I mentioned.
Because I did hear of a lady who wrote to us and said that my ex wants to have lawyer-guided mediation, but I can't afford a lawyer. So she could have still gone to the mediation without a lawyer, and that's okay?
Absolutely. Yeah.
Okay.
And she's expected to.
Okay.
And you protect yourselves in the way that we've talked about, I think, in one of the other podcasts about how you can make sure you're not bullied in that system.
And I know we've kind of touched on this already, but let's just reiterate. When shouldn't people reply to a lawyer without getting legal advice? When is it best to stop, put the letter away, and go and get some legal advice before answering?
I think the biggest one for me would be when you get an offer from the other side. If they send you an offer and it's under Section 114, as it is now of the Family Law Act, it has ramifications for costs. If you don't accept this offer, the court then at the final hearing, if your outcome is the same as or slightly worse than the offer they've just given you, you may be up for their lawyers' legal fees as well. So it's a real double jeopardy. When you get a letter with an offer in it, you really have to go and talk to a lawyer about that letter and what you should do about it. I mean, you think you may have your case all sorted and you know what the property is, but you need to evaluate that offer, I think, with a lawyer, with an independent person who knows the law.
And Mum, you always talk about your bright, shiny case outcome, your big goal that you dream of getting, but you also potentially might not get that. But the cost of holding out for that sometimes can be that you may pay their costs. So we've got a great episode on costs in Calder Bank Office if you want to go listen to that to learn more about the nitty-gritty and legal side of that. We've also got Divorce Deals 101, all those kind of things you should do before you accept or get an offer. So go and listen to that. So the times that they should really just put the letter down and not respond until they've got legal advice is if they get an offer. Are there any other times they should probably go and see someone?
I think people will know. I mean, if you get accused of stuff and you can answer back and say, no, that never happened, then you probably can respond to those things. But again, I think that it's hard for you to know what is vital to respond to and what is not vital to respond to. So maybe accumulate a letter or two and get an appointment with the lawyer to look at those. But definitely with offers, and if you're about to send an offer, I think both of those occasions are really important for you to talk to. The other one, Laura, is if you get a letter and it makes you angry, right? It happened to me. I can remember being in a shopping centre and I read the letter. And luckily there weren't emails in those days, but I was really angry, particularly if you've got a manipulative and controlling person who just tells lies. And I got so upset. Thank God I couldn't send an email because I don't know what I would have said and would have turned up on an affidavit probably later on. So if a letter makes you angry or emotional, give yourself some space. Most of us, we're reactive people, particularly in divorce. We get something happens and we immediately react. Try to give yourself a little space in the middle where you can go, oh, really? And when I was a practicing solicitor and I would write one of my, I am indeed surprised, or with the utmost respect, which for me was pretty firm language, you'd find the letter was full of things like incredible or outrageous. So I used a lot of words in there that I would give it to my secretary and wait. And the next day I'd have a look at it and go, whoa, and crossed out all of the superlatives and all of the adjectives that were unhelpful anyway.
Yeah.
And so even though you're not a professional, the person you're writing to probably is, you need to be professional, but don't try to write like a lawyer does. Just
in saying that, about the gap, like you're saying, give yourself a gap. So I think because we're in a world where text messages are so quick and you get a message, you text straight away, you get an email, you feel the pressure to answer that same day.
Yep.
In the legal profession, do they expect a letter back from a lawyer the same day?
No.
So is there a kind of a cadence or a rhythm of emails and times that maybe self-repped people don't realise exist?
Yeah, and it may not really exist for you because this is why it exists for lawyers, but you can apply it to yourself. Lawyers have it because lawyer sends a letter to your lawyer. Your lawyer sends the letter to you. You give instructions about that letter. Your lawyer might even give advice about the letter, give instructions, and then the lawyer writes back. So there's stuff that happens before the lawyer who wrote the letter gets their answer while they sort out instructions and refine and things like that. So you can give yourself a day or two normally when it's not urgent. Or you'll often find people are given 10 days or 14 days to answer things. Unless it's urgent, it's usually okay to take 10 or 14 days.
And most lawyers have other cases too. So whilst to you, it's your one case.
It's your whole world.
And it is your whole world. You kind of have a bit of breathing space because you're not a lawyer. You don't have other people's cases. But you could think, okay, well, they don't want a response the same day. So don't get caught up in that trap where you feel like you have to answer straight away. You can take that break because if you did have a lawyer, the lawyer would send you the letter. You'd talk to the lawyer about the letter. They'd write a response, send you the response to check. And then you would agree with the response or not agree with the response. Then the lawyer would write to the other lawyer. And that's going to take at least 3 days.
And you know what? That process that you described, getting instructions from you giving instructions to them, it's considering your response and you're sending a considered response. An off-the-cuff, angry, outraged email is not a considered response. But all emails have the potential to end up in front of a court and you might regret it.
So can you give us some example ways to say, I disagree? Like, how do lawyers, in a nice way, without making things worse, disagree with what's been written to them?
Okay. So a lawyer will say, in consideration of your letter or responding to your letter and using the same headings, if they've done headings or something, or other way, responding to your letter, my client instructs, and then they'll put the points. If you're writing it for yourself, you might say, in response to your letter, I say the following. And then I think I'd do a little heading for each one. Just keep it very dot point. So if they've written a rambly letter and you've identified that there's 5 complaints or 4 proposals, you can distill it down and just say, yes, these are the things to say. These are the things I'm responding to. Family report. I have no problem with having a family report. However, we already have one that was just done 4 months ago. And I attach a copy for your information. Because you sometimes are correcting the wrong things that are being told by the other side. Or you might say, contact, I do not agree with your client's assessment of what has been happening. You can say that. And then you need to go a bit further and say, what I think or what I say is happening is this.
Right.
So it's kind of,
so if you got a letter,
neutral, yeah.
So if you got a letter and it's talking about handover, family reports, selling the car and, I don't know, mediation, you just have the heading, selling the car, ... I say this, mediation, ... And so you're kind of keeping it in its little containers, short, sweet.
And methodical.
And methodical. Okay.
And if you can agree on things, that goes a long way with the court. So if there's anything that, if you agree with selling the car, for instance, I agree with selling the car and I propose to whatever, what would your client agree if we give the car to such and such to sell, or you know what I mean, or we list it to sell. So try to find something that you can agree on if you can, and ignore if they've used sort of pokey, annoying, smart aleck language to you. Just rise above that.
Now, I'm going to point out something that I've noticed with a lot of self-repped people.
Okay.
And because you feel like, okay, their lawyer will guide me. They know what they're doing.
Yeah.
But the problem with letting the lawyer on the other side lead the case or lead the negotiations or run the show is it's your ex running the show and it's not you. So don't be one of those people who only ever just responds to a letter. You need to be proactive. Why are you negotiating? Why are you talking to them? What is your end goal? What are you trying to negotiate? Because like you said, Mum, if they've sent you a big, long, rambling letter complaining about 5 different things, but none of it's moving the case forward, when you do write back to them, what can you include to move it forward? You know, what are you writing about for you?
So in that case, like I said, you answer to what you can. You agree with what you can. If you don't agree with things, try to find a way that could be resolved. For instance, the kids don't want to see you, but my understanding is the children don't want to see you, but perhaps we can have a family report. Or my understanding is the house is worth this much and not what your client says. Can we have a valuation? And here's 3 valuers. So the lawyer told me, my old boss told me when I started, he said, when you open a file, he said, do everything that you can do before you close the file. And so you've got a letter. It's a doorway into getting your point across as well. So don't let your response, like you said, Laura, be just batting the ball back to them with a tisn't. Move it forward, because who knows, the other side may not do that. And also, if you do rely on the other side to do it, they are acting for your client. There's a reason why it's an adversarial system in the court, because you advocate one direction or another. And the lawyer for your ex is not going to have your best interests at heart. And also, they will actively avoid you relying on them. That's another reason why you should only respond or have communications in writing, because they'll think, otherwise the person might think I was helping them as well. Conflict of interest.
And let's have a look at the 4 different personality types. So we've got amicable, high conflict, manipulative, controlling, and avoidant. So let's start with avoidant. What are your tips for any avoidant people or for people who have an avoidant ex when negotiating and writing letters to their lawyer?
It's hard, okay? And I do think if you're writing direct to your ex and they're avoidant, put something neutral in the subject line so they get a hint of what it is. Oh, it's only about selling the car, or so you go reselling the car, and then they can sort of bring themselves to open it. As for you, if you can't respond, get a trusted friend perhaps to open the letter for you and then see where you go from there. I think that if you see yourself as on a line that is ultimately going to end in your freedom, it can't start until you start walking that line. And so if you need to get some therapy or counselling, do that. But otherwise have a strong friend do it with you. It's not going to be that hard. I mean, everyone's supposed to be working towards resolving it and getting you out as cheaply as you can, as quickly as you can, and with the least amount of emotional damage.
And you're not supposed to know how to unpick it right from the start. You've just got to start. And I did see a really good quote. I think we've put it on our Instagram feed, but it's, the way won't be shown to you, the way won't be clear until you start walking that way.
Yeah.
So you just got to start. You've just got to start.
There's a lot of what if he says, what if she does that? What if this happens? What if that? Well, we can only deal with what's happening at the moment.
So what about high conflict? Dealing with high conflict and their ex, I guess is going to be a lot of he said, she said, or they said. Like, so what do people need to be aware of when writing to a high conflict ex's lawyer?
So I think in your mind you need to say, in your heart, don't put it in the letter, but just because they write it down doesn't make it true. And so you might feel buffeted with all of the lies and all of the attacks, but you speak your truth. You deny the stuff that they've said is wrong, and they can argue back and forth. It doesn't matter. You've spoken your side. They've said theirs. You don't have to agree. That's why there's a family court and why you have a mediation process and why you're not still together. So speak your truth and then leave it, right? And if they keep hammering on, you say, I told you what I feel. Here's that letter. Have another look at it.
I already addressed this issue in this letter. Right. I attach a copy here.
Yeah. And a high conflict, and a high conflict person would love, if you've got a lawyer and they don't have a lawyer, then they can write to their heart's content. And every time your lawyer gets a letter, they charge you for reading it. They charge you to send it to you with advice. They charge you for responding. And then, it just gets on and on. So be careful with a high conflict person. And it may be that you have to do some of the early stages yourself to save your money for the trial if there is one.
Okay. What about manipulative and controlling? What kind of things do people need to be aware of when writing letters to their lawyers?
If you've come out of a relationship with someone who is manipulative and controlling, particularly if it's been a long relationship, you've been under that spell for a long time. And you will tend to place more importance on what they say than it probably warrants, okay? And so try to gather your energy up and just dispute what they say. Don't let them run the agenda. Don't let them, for instance, give you the name of one mediator or one valuer. Just don't let them set the timetables without giving you an option, because a manipulative and controlling person may well be choosing representatives who they think will be more favourable to them. And it's not fair. You find yourself going into mediation, perhaps with someone that your ex already knows, they've set it up, sometimes even at their office. And so you're diminished before you even start, if not in your own eyes, at least in their eyes. They've got you right where they want you. You're at their lawyer's office with the mediator they've chosen. And then they'll probably, manipulative and controlling people may well want to be able to be in the same room with you and all of that. So, and for you not to feel too helpless, you need to have some say in that.
And I think a really good episode for anybody in that position needs to listen to our 10 essential boundaries for divorce. And we talk about all the boundaries you really need to set up to keep firm when going through this, particularly if you're self-repping. What is it that you need to do so that you can't get manipulated like that, and that you're going to be okay going through this process? Because those boundaries are really important. And I think that's an important point to point out. Now, Mum, we've got amicable.
Yes.
So if you're writing to your ex's lawyer, but you're amicable, is there any tips?
I think still keep it professional and still don't let them say things that aren't true. Just gently correct them. If you're scared to speak your truth, I doubt it's really an amicable relation. And of course, if you've got going back to high conflict or manipulative and controlling, they've been doing that with you for years. So it's very, as well as you having to realise they don't have any power, it takes a while for them to realise they don't have any power. And I think with an amicable person, if it's truly amicable, they still need their own representation. Still, you can't rely on their lawyer to be giving you advice, because whatever question you present to a lawyer, there is always two sides, and we are hired guns, and that's your ex's hired gun, and they're not going to be in your best interest. So you'll have to keep your wits about you, even if it's amicable. Think of it like a business deal.
Yeah, I do. I do think that's the one that where people are in danger of thinking, oh, their lawyer will lead the way, their lawyer will show us how to get this sorted. Just in any of the divorce personality types, if you've got a lawyer on the other side and you're the self-rep, don't rely on their lawyer to show you the way, because that's risky.
And also don't rely on their lawyer to tell you what's fair, because
or what the law is.
Or what the law is. They don't have a duty to tell you the stuff that you could say. They only have a duty to their client. So that might be another time when you go and see a lawyer with that first letter when you get it.
Now, I am very mindful of the time.
Okay.
I'm just going to put in here, I do know people using ChatGPT to get their letters sounding a little bit more professional. I think there's a danger in making your letters sound like they're written by a lawyer when they're not written by a lawyer. And if it's in wording you don't understand, do you actually know what you're saying? So be careful when doing that. Sure, get it to fix your grammar up, get it to fix your spelling, but be very mindful to get a lawyer letter written by ChatGPT if you don't understand what it actually says.
Absolutely, because ChatGPT gets it wrong so often anyway. But also too, I always say about if you're writing affidavits, and I think it extends to letters that you write, you need to make it live, and it has to be congruent or relevant to how you speak. And I learned that very early on in my career. Someone had used a precedent out of one of the family law books for a fellow who'd left school at 15. And the letter was written, obviously the affidavit was written by the lawyer, signed by him. Was he 15? Yeah, he was. It was a criminal matter. And the other lawyer, the barrister, said to him, so what does congruent mean, for instance? Oh, I don't know. It's in your affidavit. You swore it, didn't you?
And you've got to be careful.
Yeah, that's right.
You've got to write it the way you are. And Mum, like you said, most self-represented letters that you've received over your years of being a lawyer, they're just normal people writing normal words, trying to get their message across. So if you're sitting here freaking out going, I don't know how to write to a lawyer, I'm really scared. Don't be. They're just people
Yeah, we are.
Yeah, but just remember that any letter that you do write can be put in an affidavit and can be shown to a judge. So you've got to be really mindful about what you write. Now, last thing, Mum.
Yes.
What is the one thing you wished every self-represented litigant knew before writing back to a lawyer?
I think it is that they need to do some homework first to write back, because sometimes a person writing back to a lawyer can put their foot in it in terms of their own case or make a concession that they shouldn't have made. But yeah, I think agreeing to things like don't touch the super, or I think that's the big one, or we're going 50-50 without having legal representation. Because if you write back with that sort of proposal, if you agree with that sort of proposal, then it's really hard to get your ex off that level when you go and get advice and think, oh, actually, I shouldn't have agreed to that.
So everyone should, and we always say this, go and find out where you stand. If you can't afford to have a lawyer write letters for you, you could probably get enough money together to go and see a lawyer once.
Yep.
Show them all your information. Say, this is my situation. What do you think I'm entitled to? Get some understanding of where you stand in your specific case, so that at least through education, you are able to then respond to the lawyer's letters, like you said, Mum, without stepping on a landmine and accidentally admitting to something or causing something that you didn't inadvertently want to cause.
Yeah, that's right. Or you thought you weren't entitled to something, so you surrendered the right to that. And then it looks a bit funny. And it's hard to say, oh, they've changed their mind when they got lawyers.
But can they change their minds?
Yes. Yep, nearly
as long as it's not signed and filed?
Yeah, as long as you're not signing for documents, consent orders or anything, you can change your mind, and people often do. And I use that analogy of that Polaroid picture, as the case becomes clearer, your understanding of what your entitlement is may change.
Yeah. So please go listen to that Read a Letter Like a Lawyer episode, because that's really great if you are writing in response to. Please also, if you are stuck in getting your legal communications started, you can, if you can't afford a lawyer, you can go to community legal services. There's legal aid, there's women's legal services. There's a lot of free legal services out there. There's definitely the website Communities Legal Services available. We've got a great episode on how to access that with Cara Cook, who is now an MP, which is amazing. So she's now helping people in the whole of Australia. So go and listen to that episode if you're nervous about accessing any information. And the Family Court also has a helpline now that you can call, and they can give you some guidance too. But that's when it's relating to the family court. But if you're negotiating with a lawyer, I think you do your best. You be polite, you be honest, and you try and move the case forward. And I think that as long as you've seen a lawyer and you know where you stand, I think that's the best you can do if you can't afford a lawyer.
Yeah, I think that's right. And don't let them be mean and nasty to you. Call them in, hold them to account, refer them to the Central Practice Direction, and West Australia has one similar, and require them to tone down their language.
Awesome. All right. Good luck to anybody who's listening to this who's taking that step forward. It's not as hard as it sounds.
No.
As long as you've got the right information behind you, you can do this. And luckily with ChatGPT, you can do it with good spelling as well. So thank you, Mum, for your time. And thanks to everybody to listening. And if you are going through that, please go listen to that episode on how to read the letter. All right. Thanks, Mum. And we'll see you all next week.
Okay. Bye, Rosie.
Bye,
everyone.
If you found this podcast helpful, we'd love it if you could rate, review and subscribe. By doing so, you are spreading the word to help someone else just like you. Lynn would like to remind you that this podcast is general advice only, and you should always get legal advice in relation to your particular situation. And remember that the Australian laws may have changed since recording.